A tiny signature mistake could now cost you and all of the immigrants their American dream. The United States government is tightening the immigration rules once again, and this time, even a copied or a digitally generated signature may lead to a visa application that is being rejected or denied. Hi, this is Navya Bal, and you're watching TimesXP Immigration Desk. The US Department of Homeland Security has published a new interim rule that gives immigration officers a broader power to reject the applications if the signatures are found invalid, even after the application has already been accepted and processed. The rule was published in Federal Register on 11th May 2026, and this is expected officially to become a rule by July 10th, 2026. Now, technically, this is not entirely a new policy. Now, US authorities say that the signature requirements already existed earlier, but according to the Department of Homeland Security, the rules were often applied inconsistently, creating confusion among the applicants who were about exactly to count it as invalid signatures. Now, the government is trying to make a policy stricter and clearer. Under the updated guidance, the handwritten signatures remain the safest and most accepted option. USCIS may also continue accepting the scanner copies or maybe the originally handwritten signatures as well as the faxed or photocopied signature documents. But several types of the signatures may now trigger a serious problem, serious than you can think of. And according to this rule, copy-pasted signatures, digitally generated signatures, signature stamps, and software-generated signatures, all of them made by anyone other than the applicant itself, may be treated as invalid. Even attorney or representative signing on the behalf of the applicant may not be accepted unless specifically authorized under the immigration rules. Moving forward, electronic signatures will only be allowed if the situations where USCIS officially permits to do so. Now, the immigration experts say that this may look like a small technical change, but the consequences may be massive. Because under the new rule, USCIS reject or deny the applications even after processing and if it has already started. And now that means that the applicants could now file the fee, lose the valuable waiting time, and in fact, some cases completely miss the legal filing deadlines. And for many Indian professionals in America, that risk is extremely serious. Experts say that involving H-1B visas, the PERM labor certification, and I-140 green card applications could now face a major complication if the signature issues are discovered months later. And in some situations, applicants may not even get a second chance. The agency has reportedly clarified that there is no simple fix for the invalid signature case denied. Instead, applicants may have to file the entire application to the entire process from the very beginning. Immigration lawyer has also advised the employers and the applicants to take extra precautions immediately. She also recommended that verifying every signature filed before the filing, before the major reforms, avoiding the signature software unless clearly authorized, and now carefully reviewed the USCIS instructions on paper signature compliance. Well, now this development comes at a time when immigration scrutiny is also very high as far as security is concerned, from H-1B visa review to green card backlogs and student visa concerns. Many immigrants are already facing the growing uncertainty inside American immigration system. And tonight, the message from the US immigration authorities appear to be very clear. Even the smallest paperwork detail could now decide the future of immigration application. So, are you ready for this? Make sure to comment down below.